We've all heard contracts need promises going both ways, right?
Mhm.
A real exchange. But today, we're digging into something tricky in contract law.
Yeah.
What about agreements that seem commercially solid, but on paper, one side hasn't actually promised to do anything specific?
Yeah, it's a classic problem.
How can that be a real contract? Where's the commitment? We're looking at those exclusive dealing contracts, the ones that could look, well, really one-sided.
That's the core challenge, absolutely. It touches on basic contract validity consideration, this idea of mutuality of obligation. The real question is how courts step in to, well, save these deals when everyone clearly intended something commercial, even if the wording was sloppy.
Okay.
So our deep dive today will focus squarely on this idea of implied promises. Specifically, we'll unpack that huge 1917 decision from Justice Cardozo, the one that gave us the instinct with an obligation standard.
Right. Okay, let's tackle that doctrinal question first then. If someone gets an exclusive right, say, an agent gets the sole right to market a product, but they don't explicitly promise in writing to, actually try to sell it, why isn't that contract just void? Doesn't it fail for lack of consideration or this mutuality thing?
That's exactly the argument people used to make, and often successfully. The old way of thinking, the really rigid view that Cardozo was pushing back against.
The primitive formalism you mentioned.
Exactly. That view said, if I give you an exclusive right and you don't write down exactly what you promised back, the whole thing collapses. No mutuality, no contract. The precise words were everything.
Okay.
But modern contract law, well, it's more tuned into business reality. It takes a broader approach.
So what's the rule now?
The general rule now is basically this. If you look at the whole agreement, the whole document, and it clearly has a commercial purpose, the court can imply a promise to perform. It does this if the entire writing is, quote, instinct with an obligation, even if that obligation isn't spelled out perfectly.
Instinct with an obligation.
And usually that implied promise is a duty to use reasonable efforts. You can't just accept an exclusive right, especially if the other person's payment depends entirely on your efforts, and then say, oh, but I never promised to do anything. The acceptance implies the duty.
So the court's essentially reading between the lines saying, look, we see the business deal here, even if you messed up the drafting. Which brings us perfectly to the case that really cemented this idea. Wood v. Lucy, Lady Duff-Gordon. This one's foundational, right?
Oh, absolutely. It marked a major shift from fixating on literal words to understanding the commercial intent behind them.
All right, let's analyze Wood v. Lucy, Lady Duff-Gordon. First, what are the legally dispositive facts? Lay them out for us.
Okay, so Lady Duff-Gordon. She was a big deal in fashion back then. A creator of fashions, as she put it. She figured out her name, her endorsement, could sell things.
Smart lady.
Very. So she made an exclusive deal with this fellow, Otis Wood. He got the exclusive right for at least a year, mind you, to put her endorsements on other people's designs, and also to market her own designs.
Exclusive right. Got it. And how did she get paid?
That's critical. Lady Duff-Gordon's sole compensation, her only payment for giving up this exclusive right was half. 1/2 of all profits and revenues that came from the contracts Wood made.
Solely from his efforts, then.
Exactly. The problem came up because, well, she apparently went behind his back, placed some endorsements herself without telling him, and kept the profits. That was the breach.
How did it get to the high court? I remember something about the procedure.
Yes, that's right. It came up on demur. Basically, she argued that even if everything Wood claimed was true, she should still win because the contract itself was invalid. Her argument was simple. Wood never wrote down, I promise to use my best efforts, or anything like that. So no promise from him, no mutuality, no contract.
Okay, clear facts. And what was the core legal issue the court had to decide?
The issue is pretty precise. In an exclusive agency deal where the agent doesn't explicitly promise to do anything, can the law step in and imply a promise to use reasonable efforts? And if so, does that implied promise create the necessary mutual obligation to make the contract valid?
So can the court fill in that missing promise? What rule did the court apply?
The court, well, Justice Cardozo, writing for the court, applied the rule we just talked about, that where a document is instinct with an obligation, where the whole context screams that performance was intended, then a promise to use reasonable efforts is, quote, fairly to be implied. And that implied promise is enough to defeat the argument that the contract is too indefinite or lacks mutuality.
Cardozo had that great line, didn't he, about the law moving beyond primitive formalism. Something about that precise word not being the sovereign talisman anymore. What did he mean by sovereign talisman? Like magic words?
Pretty much, yeah. He was saying the law had matured. In the old days, maybe the 19th century, if you didn't use the exact right legal phrase, the talisman, your whole deal could just fail, even if everyone knew what you were trying to do. Cardozo rejected that. He argued that modern business needed a more practical, dynamic law that looked at the substance of the agreement, the overall purpose.
Right. It shouldn't just be about whether the lawyers use the perfect template.
Exactly. If the intent to make a real business deal is clear, the court should focus on that, not just the syntax.
Makes sense. You wouldn't want someone like Lady Duff-Gordon to get out of a deal just because Wood's lawyer forgot one sentence. Okay, so what was the court's detailed analysis? How did Cardozo justify implying that promise?
His reasoning was, well, quite elegant and layered. First point, the exclusive privilege implies duty. He stressed that she gave Wood an exclusive right for at least a year. When you accept an exclusive agency like that, Cardozo argued, you're implicitly taking on the duties that go with it. You can't just take the exclusivity and do nothing. It inherently suggests action.
But why does exclusivity automatically mean duty? Couldn't she just have made a bad deal, giving him exclusivity without requiring effort? Why should the court fix it?
But that leads directly to the second, and probably most powerful point, the compensation structure. Remember, her only way to make money from this deal was through Wood's efforts, that 50% cut of the profits he generated.
Right, the sole compensation point.
If Wood just sat back and did nothing, she got absolutely zero. That payment structure just doesn't make sense unless you assume Wood has to try and generate those profits. It forces the conclusion that he promised to work at it. If she'd gotten, say, a big flat fee up front, maybe the analysis changes. But here, her income depended entirely on him.
So the money trail itself points to the missing promise. That feels very grounded in commercial reality. Was there anything else Cardozo pointed to?
Yes, he looked at other parts of the contract, things that might seem minor, the recitals and other promises. The contract mentioned Wood had a business organization adapted for this kind of work. Cardozo saw that as implying the organization was meant to be used for her benefit.
Plus, Wood did make some explicit smaller promises. He promised to account for money he received each month and to handle patents or copyrights if needed. Cardozo argued these smaller promises would be pointless, valueless was his word, if Wood didn't have the main underlying duty to actually market the designs and generate profits in the first place. What would he account for otherwise?
So those little promises act like clues, reinforcing the idea that there was a bigger unspoken promise to actually perform the main job.
Exactly. Cardozo said all these elements, taken together, enforce the conclusion that a promise was intended. And then there was the final powerful policy argument. Courts shouldn't interpret contracts in a way that puts one party completely at the mercy of the other. Lady Duff-Gordon gave up her ability to make money from her own name through others for a year. The law shouldn't assume she intended to get potentially nothing in return. It prevents the deal from being illusory.
Okay, so weighing all that in the conclusion, what was the final holding? The court found there was a valid, enforceable contract. They implied the promise from Wood to use reasonable efforts. Therefore, the lower court's judgment, which had favored Lady Duff-Gordon based on the lack of an explicit promise, was reversed. Wood could proceed with his lawsuit for breach.
Okay, that's a really clear breakdown. Now, let's cement this. Give us one of those memorable, visceral hypotheticals. Lock in the rule.
All right, how about this?
Imagine a small artisanal baker. He makes this really unique bread, but it's bizarrely shaped. Really weird looking. He grants a marketing firm the exclusive right for 3 years to sell this strange bread. The firm happily agrees to the exclusive deal. Here's the key. The baker's only pay is 60% of whatever profits the firm makes selling the bread. The contract says nothing about whether the firm actually has to market it. 6 months go by. The baker sees zero effort, zero sales. His weird bread is just sitting there. The firm says, hey, tough luck. We never promised we'd actually sell anything.
Okay, applying the Wood v. Lucy logic, that marketing firm is likely in breach. You nailed the 2 critical factors in your hypo.
The exclusivity.
Yes. First, the baker gave them an exclusive right. He put himself totally at the mercy of that firm for 3 whole years regarding his bizarre bread sales.
And the payment.
And second, crucially, the baker's sole compensation, that 60% cut, depends entirely on the firm's efforts. If they don't sell, he doesn't eat, metaphorically speaking.
So even if that bread looked truly ridiculous and maybe tasted awful, the firm still had to try. They couldn't just sign the deal and ignore it.
That's the power of the implied promise. Because of that combination, the exclusive right and the compensation structure tied to effort, the agreement is instinct with an obligation. The law implies a promise.
Hmm.
The marketing firm had to use reasonable efforts to try and sell that weird bread, doing nothing for 6 months. That looks like a breach of that implied duty. They accepted the duty when they accepted the exclusive deal structured that way.
That really clarifies it. The structure of the deal itself creates the obligation. Okay, let's wrap this up with a synthesis. For our learners facing an exam or reviewing a contract, how do they spot this issue and apply the rule effectively? Can you give us that step-by-step diagnostic checklist?
Absolutely. When you see a contract involving exclusivity, especially if a promise seems missing, run through this checklist. Think of it as the Wood Rule diagnostic. Step 1. Is there an exclusive deal? First, just identify, did one party give the other an exclusive right to market, to distribute, to endorse? Is the grantor relying solely on the agent in that specific area? That's your starting point.
Okay, exclusivity first.
Step 2. Is compensation tied to efforts? This is really the heart of it. Is the grantor's main or only payment a share of the profits or revenues that the agent generates? If payment depends on performance, the implied duty is strong. If they got paid a big chunk up front, regardless of what the agent did, well, the argument for an implied duty gets weaker.
Got it. Compensation structure is key. What's next?
Step 3. Look for the small stuff. Are there recitals or minor promises? Scan the contract for those other clauses. Does it mention the agent's special skills or business setup? Are there promises about accounting or getting patents? Things like that. These details, as Cardozo showed, really enforce the conclusion that a primary performance duty was intended all along.
Right, those reinforcing details. And the final step.
Step 4, the conclusion. If you've checked off yes for step 1, exclusivity, and step 2, compensation tied to efforts, and maybe you found some supporting details in step 3, then you can likely conclude the agreement is instinct with an obligation. The court will probably imply a promise of reasonable efforts from the agent. This provides the necessary consideration or mutuality and makes the contract enforceable, not just an illusory promise.
Fantastic. So the big takeaway today seems to be that contract law, at least in this area, grew up. It moved past demanding magic words, that primitive formalism. When the business intention is clear, especially with exclusive deals, courts will look at the substance to protect what the parties reasonably expected.
Exactly. And it's worth remembering this isn't just dry legal doctrine, it's driven by policy. It's about ensuring fairness in commercial dealings. It stops one party from being locked into an exclusive arrangement, taking all the risk, while the other party has technically promised nothing and could just walk away or do nothing. Here's something to think about. How does this fundamental policy of implying reasonable efforts play out in modern franchise agreements? Think about a big fast food chain. The main company, the franchisor, grants exclusive territories and relies almost entirely on the individual franchisees using reasonable efforts, acting in good faith, to maintain the brand standards and generate revenue. That whole system rests on this kind of implied obligation.
That's a great point to consider. The ripple effects of Wood v. Lucy are still shaping business today. If you take the benefits of exclusivity, you take the burden of effort. That's a powerful idea. And that's all the time we have for this deep dive. Thanks for joining us.
My pleasure.